Good afternoon. Happy Friday. My hair looks weird. There's like this bump in it. I got a bump in my hair. Bump it! So there was an order issued in the Decastro versus Wagner case, and Decastro has once again played his I'm just a silly pro se litigant, and he has been given the opportunity to respond, file his opposition to the defendant's motion to dismiss and motion for summary judgment, respectively. Now, again, I didn't know which way it was going to go. And now that I know which way it was going to go, I said it's going to go one of two ways. I said, either the court is going to say, no, you can't file your response and get rid of it that way, or the court's going to be like, you can go ahead and file your response and then get rid of it on the 12B6 and the motion for summary judgment. 12B5 and 12B6, I think. Anyway, so that looks like the direction we're going. Chile's motion is his opposition to their 12B6 and 12B5, I think, motions was garbage. I went over it in the past when it was attached to his motion for leave to file a late response opposition. He calls it a response and opposition. In the Wagner one in Ohio, it looks like they do responses and opposition. So that's kind of a weird thing to me, but it seems like it's a local flavor. They don't appear to do that in the First Circuit. They don't do that in the Ninth Circuit. I mean, maybe Paul Carroll has a better understanding of why they title their oppositions response and opposition. It's just weird to me. But, Texas has weird headers, and, everybody does things weird and different. So, I can't really say much other than a response and opposition looks out of place in the First Circuit because they just file oppositions in the First Circuit. So the response and opposition is now docket 32, and the court is giving the defendants, I believe, until the 27th to file their replies. And that's the way it normally goes, is motion, opposition, reply. So the moving party gets to file the reply. They, generally speaking, get the last bite at the apple, the last opportunity to make their case, at least until it comes to oral arguments, if there are any oral arguments. So that's what we got going on. Short video. That's another thing. I have reached out to Corey Zinman, who appears to be a public defender out of Florida. I'm going to see if I can't get him to number one, give me all the documents in the Zinman versus Stout case. And number two, I would like to interview him to see what's going on there. So hopefully I get a response back from him. In addition, I have asked people to get a hold of Reyes, Long Island Audits, to see if he will give me copies of all the documents that have been filed in his case against Mr. Stout. I don't really know a lot of what's going on in either case because I haven't read the documents, but it'll be interesting to see how much of a legal genius our boy Mark Stout is. On a completely different subject, I watched the video the stream that James Freeman did with some guy I don't know and an attorney who is a real attorney. And it was interesting hearing that real attorney saying a lot of the same things that I was saying. One thing I do disagree with that other attorney on, he thinks that freedom of the press is going to be the way forward. I don't. The freedom of the press, it's the same right as everybody else has, and it basically boils down to a right of access. And we've seen quite a number of cases on the right of access, like the right to film inside of a courtroom, because you have a right, there's a right to a public trial, and there's also a right to access. So there's a lot of right getting you in there to see a trial, right? Not the defendant has a right to a public trial, and you have a right to access. It's part of freedom of the press. And that's kind of how the founding fathers saw all this going down, is people get to see it and they see what happens. And it's not a star court or whatever they call those things, a secret trial, so that people can report on it and say, yeah, it was fair. No, it wasn't fair. Yeah, I believed it. No, I didn't believe it, blah, blah, blah. So there already is a lot of jurisprudence on the right to access, i.e. the freedom of the press. And your right to access does not mean that you have the right to do pictures or audio recordings or video recordings or anything like that. There's just a lot of case law on it. And, I'm sorry, I don't think that's the way forward. Another thing that didn't seem to get understood in the Freeman live stream was that Veritas case out of the First Circuit. The Veritas case out of the First Circuit. The First Circuit has taken that right to film public employees engaged in the performance of their duties. You can film them from any place you're entitled to be. That Veritas case, if you read it, that's the proposition it stands for. That court took all of the language out of Glick and Garricky, and it said, no. These aren't forum analyses anymore. You might have thought they were forum analyses, but they're not. It is not a forum analysis anymore. It is just a reasonable time, place, and manner restriction. It's an intermediate scrutiny test. You can film a public official, which is different than a public employee, but you can film a public official in the performance of their duties from any place you're entitled to be, subject to reasonable time, place, and manner restrictions. So they were thinking that wasn't established, and I think it is, at least in the First Circuit. Now, the Ninth Circuit says entirely opposite. It's just a forum analysis. So there's a split in the circuits, but you have at least one circuit now that has made that a non-forum test. So what forum you're in doesn't matter. And eventually, if enough circuits split down the lines on that might actually get to the Supreme Court. That might be enough for the Supreme Court to say, hey, okay, we need to look at this because you're getting different results in different jurisdictions. Another case is that Garland v. Price, where the Court of Appeals for D.C., the D.C. Court of Appeals, said that recording something is not expressive communication, which I think is ridiculous. But they're the only circuit that I know of that has come to that conclusion. That is a really weird conclusion. People are placing a lot of stock in it. I wouldn't place that much stock in it. Most of the places you're going to be filming are going to be outside of the very small physical area that is governed by the Court of Appeals for the District of Columbia. Very small, like a 10 square mile area or something like that. It's a ridiculously small circuit. So I wouldn't place a whole lot of emphasis on it. Yes, be aware of it, but it's kind of its own weird thing. It doesn't make a lot of sense when you try to line it up with what the other circuits have done. It's an oddball. So don't get too wrapped up in it. Understand it exists. So, and then I thought there was something else that I wanted to bring up on the Freeman stream. Anyway, maybe someday I'll go through it. So, recap. Chili's opposition to the motion to dismiss, etc., has been filed in Decastro versus Wagner. The defendants who filed the motions to dismiss, they get until the 27th to file replies to his pleading. Then there's going to be a ruling on it, and probably the motions to dismiss and motion for summary judgment are going to be granted. Probably. The question of whether or not Chili's going to get another bite at the apple to file an amended complaint, that's a different story. We don't know. Could be, maybe not. We'll have to see what happens there. And then I've reached out to Corey Zinman, excuse me. I'm going to try to get copies of the Zinman versus Stout documents, and I'm going to see if he's willing to come on and do a live stream with me. I have people reaching out to Long Island Audits, Reyes, to try to get copies of those documents. And I'm not entirely sure how fruitful a live stream with him would be. I don't know how much analysis he would be able to shed on it, but I would not be opposed to doing a live stream with him if he wants to come on to do that. And then the attorney on the Freeman stream, very, very similar to me. I think I have a little bit better understanding of the First Amendment than he does, but that's just me. I'm just a little bit cocksure because I'm a first-year family law attorney. And that guy's only been practicing law for 20 years or something. What does he know, right? Anyway, thanks for watching. Have a great day.